All right, good afternoon. Thank you all so much for joining us. For those of you who are unfamiliar with Mountain States Legal Foundation, my name is Kristen Wolgamuth. I serve as the president for Mountain States Legal Foundation, but we are not doing this event alone. We have some wonderful partners in crime for this activity. Both Texas Public Policy Foundation, which is hosting us in this gorgeous location and has helped so much with event planning, is one of our partners, as is the Texas Conservative Coalition Research Institute. Fantastic partners that we are so grateful to have on board, and we are going to be talking about federalism today. If you are unfamiliar with the concept, it is in fact an underpinning of our Constitution, despite what Mr. Biden would have you believe. And that is the conversation that that our panel is going to be having this afternoon, moderated by our very own General Counsel, Will Trachman. Thank you again so much for being here. Thank you to our amazing partners, and I will turn it over to the panel.
Thanks, Kristen. My name is Will Trachman. As Kristen said, I'm the General Counsel of Mountain States Legal Foundation. We're based in Denver, Colorado, but we're happy to be here in Texas today. It's a terrific opportunity for us to be here at Texas Public Policy Foundation. We have a terrific panel here for you today on the topic of, does federalism have a future? Let me introduce our terrific panelists today. We have 4 wonderful speakers, including Derek Cohen, who is over here, the second from the left, who is the Vice President of Policy at the Texas Public Policy Foundation. And I hope he's not embarrassed for me to say that he has met Kim Kardashian before as part of his work on the First Step Act.
It is in my academic CV.
Derek, I already need to remind you to use the microphone so that the people can hear us on the video. We do have Professor Michael Grieva immediately to my left, Professor of Law at Antonin Scalia School of Law at George Mason University. Professor Grieva is the author of a number of books, which you should look up on Amazon. They are terrific. Some of our own attorneys have read them, and they have a terrific take on our topic today of federalism. We have Russell Withers, who is the General Counsel and the Senior Policy Analyst at the Texas Conservative Coalition Research Institute. We're very excited to have Russell here with us today. Russell has advised a number of legislators in the Texas State House and is an active member of the Austin Federalist Society, which is nice. I'm a member of the Colorado Lawyers Chapter of the Federalist Society as well. And then you may notice that we don't have Melinda Taylor with us. Instead, we have another gentleman we're very happy to have, Will Thompson. Will is the Deputy Chief of the Special Litigation Unit in the Office of the Attorney General. He previously served as an Assistant General Counsel for Governor Abbott and is a graduate of the University of Chicago Law School and Georgetown University. Thanks so much to Will for filling in for Melinda today. And we are very excited to get started. So with that, I want to open it up to our panelists. Our topic today is, does federalism have a future? And I want to start with the broadest possible take on this. And I want to get everyone's notion of what federalism means, what they think of when they hear that word, and then where we are in terms of federalism today as a country. And let me start, Professor Grieva, to my left. Go ahead and give us your thoughts on that question, and we'll just go down the line and maybe take a few minutes, 3 to 5 minutes or so, and give us your take on where we are.
Thanks a bunch, and thanks for the invitation. It's a real pleasure to be here. I thought, just sort of as an opening, sort of table setting thing, I'd say a few things about where federalism, how it's developed over the past, let's say, 3 decades. I'm afraid that'll be a little grim. But it does have a future. It always has a future, as political scientists are fond of saying. It's the default setting of American politics, and it's not going to go away. And it's a very good idea to sort of pitch this as, what will it look like? I want to stress sort of 5 fairly stable features of American federalism over the past 5 decades. They all overlap, and the distinctions are a little bit artificial, but I hope it'll be serviceable. One of the aspects I don't have to mention at all, but I'll mention it nonetheless, because you can't stop me. It's become much more partisan, right? So as everybody knows, there are blue states and there are red states. That's a little overlaid by sort of a sharp political divide between rural areas and urban areas. But there's a record number of states that are under single-party control, and that's not going to change. And another facet of this development, it seems to me, is the sort of atrophy of what used to be bipartisan non-political organizations. I'm thinking of the National Governors Association, right? Regardless of partisan affiliation, the NGA had a sort of broad-based consensus, which was give us more money and then leave us alone. That has basically gone away and been replaced with partisan institutions, and it's the same whether you look at at state AGs, state legislators, and so on and so forth. The second feature is it's become federalism has become sectional. What I mean by that is that there are stable blocks of states that have non-negotiable commitments on salient issues of politics. So politics in those domains stops being transactional and starts being very contentious and ideological. So you cannot pay a state to change its abortion laws or its laws on guns and even on Medicaid, which might just be totally transactional about money. There's still 12 holdout states that have said no to the Medicaid expansion. You see the same thing on energy policy. States have very, very different business models, right? So Texas has one business model and a lot of states have a similar business model. New York has a very different business model that rests on high taxes, high transfer payments, and a very high demand, domestic, authentic demand for environmental amenities. If you want to sustain that model, you have to do two things. You have to raise rivals' costs. That is what the climate change agenda is about, right? Make it more expensive for energy-friendly states to do business. And for the entire enterprise, you need the federal government because at the end of the day, there's very little that New York can do to Texas. And these states act as blocks, and they're remarkably stable as well. The fourth factor that I want to mention is federalism has become increasingly executive federalism. Once upon a time, during the 19th century, federalism came from the Constitution. Between the New Deal and the 1980s, roughly 1990s, federalism came from Congress. That's where you haggle out federalism compromises. That has all ended. I mean, the old New Deal-ish federalism compromises are still embedded in the statutes, but the statutes are just so broad and so discretionary that the executive gets to run with them. Congress sits on the sideline because it consists of 535 performance artists who compete with the president for airtime, right? This was the first legislative session where several congressmen have not hired legislative staff. For the simple reason, I mean, we don't legislate. Why would I need a staff, right? You need a big PR staff and a fundraising staff, but not a legislative staff. And Congress doesn't monitor the executive implementation of these programs or development of these programs anymore, let alone legislate, right? So if you look back over the 1970s, the early development of the Clean Air Act, and this is just one example, some federal judge says, we have to have a Ph.D. program, prevention of significant deterioration, so that not all the industry runs from the Rust Belt states to the south. Congress immediately got into the act, wrote a version of the Ph.D. program into the 1977 amendments. That was the Federalism Compromise. That world is dead and gone, right? The Obama administration has its clean power plan. Congress has absolutely nothing to do with it. The Trump administration repeals that whole thing. Congress had absolutely nothing to do with it. And now the Biden administration will revive the Obama version or some version thereof, and Congress will just sit on the sidelines. And then finally, and that means the executive has enormous power. The executive, and in particular the White House, that's where federalism comes from now. And that lays the ground for what the founders called corruption. That is to say, the systematic use of government power to harm your enemies and to help your friends. And the executive has enormous amounts of money and enormous regulatory powers, and it certainly has all the incentives to do just that. And finally, executive federalism that we now have is debt-financed federalism for several reasons. A Congress that cannot legislate, that cannot check the executive, has one comparative advantage left, and that is to borrow money, which it does with abandon. As divided government grows, you need more money to rope dissident states into sort of broad-based programs. That's why there's 100% Medicaid reimbursement, now going up to God knows what, 110%. And then most of these federal programs induce state overspending. So periodically you need new programs to bail them out. The American Revitalization and Recovery Act in 2009, that was a bailout program. The Medicaid expansion, that's a bailout program. Lots of the COVID relief programs, those were bailout programs. All of these trends are of long standing. They date back 3 or 4 decades, and all of them are robust to partisan politics. This is not, ooh, the Dems did this to us, or ooh, the Republicans, didn't pay attention and let it happen. This is both parties want it that way, because the only prize that's really worth having in American politics now is you own the White House or you don't.
On that sunny note, Russell? Yeah.
Boy, that was grim. Don't worry, I'm going to be the optimist. Thank you to Mountain States and TPPF for having me. It's a pleasure to be here. I would agree with a lot of that. That federalism, as we generally understand it, or as it was designed, is gone. But that doesn't mean it's dead or that it doesn't have a future. I would agree that federalism is mostly at play now with respect to executive actions. And for the evidence that federalism has a future and that it's not dead, all you have to do is look around in the news and listen to what people are saying about the party that's in power. Everyone loves federalism when they're not in power. I mean, just look at the coronavirus response. I pulled a few headlines as examples just this morning. So when President Trump was in office, we were subjected to endless think pieces along the following titles. Trump versus the states, what federalism means for the coronavirus response. The administrative presidency meets federalism, hostile takeovers in the Trump era. Trump flunks federalism 101. So the Democrats loved federalism when President Trump was in office, and it had a bit of a revival. And now that President Biden is in office, I won't speak for the collective room, but conservatives in general don't like a lot of the things that President Biden is doing. So you look at discussions around national mask guidance, pretty much anything from the CDC is treated as law by blue states and largely ignored by red states. National vaccine mandates, we'll see what happens with that. In Texas, the legislature passed SB 968, which prohibits vaccine passports. So you have all kinds of push and pull that are still happening today between the states and the federal government. And also, if you just look and see what's happening in state legislatures, I went back and looked at some of the things that the legislature in Texas has been doing over the last 3 sessions. So Only 3 sessions ago in 2017, the 85th session had a House Select Committee on State and Federal Power and Responsibility. That's a federalism committee. And there were over 70 bills filed, all of which were meant to assert the state's authority in the federal balance between the states and the federal government. So you had things like the Texas Balance of Powers Act. And I'll just read a little bit from the preamble here. This act serves as notice from this state to the federal government to cease and desist any and all unconstitutional activities that are outside the scope of the power delegated to it by the United States Constitution, including those activities that unconstitutionally undermine, diminish, or disregard the balance of powers between the states and the federal government established by the Constitution. So there were all kinds of things like that that were filed and heard and worked their way through the legislature. Other things, House Bill 2808 by Representative Swanson relating to preventing the commandeering of state resources by the federal government. You had all kinds of bills dealing with gun regulations, telling local governments and state authorities they couldn't enforce unconstitutional gun regulations. A bill relating to prohibiting the enforcement of certain federal laws, creating a criminal offense for doing so. And then this session, you had a trigger ban on abortion. So if something were ever to happen with Roe, a state ban on abortion would take place immediately. That's federalism. You had a bill filed that didn't pass by Representative Schofield, HB 4507, which was a preemptive piece of legislation in case Congress passes the For the People Act. And what it would do is it would split out elections between federal and state and make sure that the For the People Act would only affect federal elections in Texas, and Texas would still exclusively regulate state elections. So those are the kinds of things that legislators are thinking about, and they are always looking to respond to things that the federal government is doing. As someone that works a lot with the legislature, through TCC, which is a legislative caucus, I've written countless letters that legislators sign complaining to the Texas delegation about things that the president is doing or that Democrats in Congress are doing. So there's always an awareness of these things and a willingness to push back. The last point that I will make is a bit of a tangent. When we talk about federalism, we talk about the power between the federal and state government, but the principle of it applies to state and local governments as well. You have overlapping jurisdictions, both with lawmaking ability, and anyone that's paid attention to anything that has happened in Texas over the last, several decades, knows that the legislature is always fighting with local governments. You're talking about things like policing policy, ride sharing, fracking, short-term rentals, abortion aid, homelessness and camping ordinances, non-discrimination ordinances, and so on. So I don't want to take us too far off topic with the local stuff, but federalism, in a sense, is at play at the local level as well. So in that sense, it has a future as well.
Excellent. Go ahead, Derek.
Well, those are definitely two tough acts to follow, and I echo everything that both the professor and Russell have said, including both the sunshine and the grim parts as well. I think when you talk about the question of whether or not federalism has a future, I definitely think it does, and I definitely think, although you can never go home again, I think that there are ways that we can kind of appropriate the same function as it was imagined in our constitutional order. Specifically, I think when we discuss conservative philosophy, when we take out the dusty old Russell Kirk book and blow it off and start reading into the tenets of conservative philosophy, we always talk about subsidiarity. And federalism as a mechanism is the best way of ensuring subsidiarity to the states. Now, we obviously have issues of subsidiarity and the barring of rights, natural rights, or even explicit rights given, even explicit rights codified into law when we have some of these, we'll say, overreach from the cities. But what we need federalism for, and why we need a rejuvenation in federalism, is because if we want a government that works for the people and not works to rule the people, that's going to be a necessary feature of that system. Russell mentioned earlier the push for basically entreating our law enforcement to not enforce any federal gun laws. And I think that was one of the under-celebrated successes of this last legislative session. This was HB 2622, I believe. And what that essentially did, we're all familiar with the Prince decision and saying that, you know, the federal law enforcement has a non-commandeering doctrine. They can't actually tell local law enforcement or state law enforcement what to do. Well, they can't tell them what to do, but you know what they can do? They can pay them to do something that they want to do. And we see a lot of those arrangements, not just in the civil asset forfeiture space, which is something I discuss frequently, but also when it comes to enforcing federal law, that nobody in the state who is actually paying for the law enforcement who will do the ultimate enforcement have actually agreed to or had signed off in a democratic process. And so I think 2622 specifically, what that does is it actually bars anything that gets passed at the federal level after, I want to say, January 20th of 2021 from being enforced through any resources of the state. Now, obviously, when Biden came in, his buddy Beto was going to be the gun advisor for him. We saw his nomination to the ATF, David Chipman, who was ignominiously pulled down simply because, I really don't know any redeeming qualities the gentleman had. But that being said, that's where we're at. But we definitely see a posture for this overreaching read of what the federal government can do in its regulation of the Second Amendment. And this is just one issue specifically. That would be the positive spin. That would be the positive aspect, seeing that Texas asserting its basically its sovereignty and its supremacy in this particular issue area when it comes to defending the rights of its citizens, was something that it should do. The dour problem is even our most conservative legislators sometimes still have that weak spot for any sort of cooperative federalism, we'll call it. Cooperative federalism is anything that when we're mandated something we do by the federal government, or else we lose 5% of highway funds, or we lose 5% of the Jimmy B. Smith grant program, or whatever the case may be. And obviously you don't need to look much farther than every grant program under the umbrella of the Bureau of Justice Assistance, where we basically have largely coerced a lot of our local and state law enforcement to comply with certain federal diktats. When this doesn't necessarily need to be in issues of firearm policy. It could also be in issues of data management and things more mundane. But essentially, once that spigot turns off, that's something that's felt keenly in the state budget. But in order to get those 5% of highway funds, the burn JAG grants that get put down into the governor's criminal justice division for disbursement, all of these basically require compliance with whatever the legislation is that surrounds it. One of the things that I work on here at the Texas Public Policy Foundation is our criminal justice work, and so much of how we run our prisons in the state is dictated by PREA. And whether it's Governor Abbott, Governor Perry, and those before him, Texas has always had a very contentious relationship with PREA. In other words, making sure that we're hitting certain staffing thresholds, making sure that we're keeping site sound separation, all these different minutia elements of that. They don't like that, and many of those things are onerous. But the 5% of all that disbursements from the BJA is a big part of the budget. And so it comes to a point where, as long as we're, to the professor's point, borrowing money in order to have policy set either at 1600 or have it set in the Capitol, the DC Capitol, we're not actually observing that system of subsidiarity. And I'm worried that that's what gets lost in it, is that, well, we'll have these outward, he used the term performative, we have these outward performative assertions of sovereignty, but it's not something that's yet intrinsically adopted. And I think that would portend worse for the future than any particular policy or issue area.
Excellent. Will?
Thank you. I'm Will Thompson. I'm not Melinda. I work for the Attorney General of Texas, and so my experience with federalism is largely either suing the federal government or being sued by the federal government, things like that. The way I think of federalism, and there are a lot of different ways you can think about it, is that we have two separate governments. States are not administrative departments of the federal government. The very existence of all of those cases called Texas versus United States tells you something, regardless of how they come out. If President Biden could fire Governor Abbott, one suspects he might be tempted to do so, but he can't in a way that is completely different than a CEO who doesn't like the head of marketing can just get rid of the head of marketing, install his own person, and the problem's gone. So I think what that tells us, though, is that's something of a de jure way of looking at federalism. And from a de jure perspective, I think fans of federalism have some reason to be optimistic. If we look at kind of legal developments in Supreme Court doctrine over the past few decades, I think fans of federalism would find some things to smile about. The Commerce Clause, for example. How much power the states have is directly tied to how much power the federal government has. And one of the major powers for the federal government is under the Interstate Commerce Clause. Well, certainly we're in a very different position today than we were at the founding, but we're also in a very different position than we were in, say, the 1970s. So you see Lopez and Morrison in the 90s, all the way through the Supreme Court's Obamacare decision, saying that at least some things go beyond the commerce power. You can say the same thing about the conditional spending statutes that we've talked about. So I think NFIB versus Sebelius, the first Obamacare case, was the first time the Supreme Court had ever held that one of those conditional spending statutes was actually unconstitutionally coercive of the states. So the Medicaid expansion, we talked about whether states are signing on to that or not. The only reason there's a question about whether states can sign on to it is because the Supreme Court held that the federal government couldn't force them to sign on to it. So we can go through other examples, but I think the basic trend is we've seen some developments in legal doctrine that recognize the state's powers more. And I think that's reflected in who our judges are today. I think most practicing lawyers who do this kind of thing would say there are more judges on the bench today who are interested in hearing about federalist limitations on federal power than there probably were 40 years ago. But of course, the de jure perspective is not the only relevant perspective here. We also need to look de facto. So what happens on the ground in practice when a state agency and a federal agency disagree? My co-panelists have talked a lot about this, but we do see a lot of state agencies are kind of inclined to follow the lead of the federal agency. Part of it will be someone's worried about losing funding. That can be a big deal. And obviously, there are legal doctrines that deal with that, but at some level, maybe legal doctrines aren't the best way to handle a situation where the state and the federal government actually agree with each other and are happy for the transfer payment to be made, right? I think we see a lot of that. There's also just a difference in capacity sometimes. The federal government can generate large portions of revenue, even if it's through debt finance, and so that puts them in a good position to buy off state opposition. So there are things like that. But I think the way that you want to look at this going forward is how can you, if you are a fan of federalism, try to kind of expand states' ability to resist those types of incursions from the federal sphere? I think a lot of it's going to be cultural. It's not necessarily something that's solved in a courtroom. I suspect we would decide based on partisan polarization today that a lot of people here probably identify more closely with their co-partisans in other states than with members of the opposing political party in their own states. Maybe we should run some surveys on that or something, but if that's the way you kind of feel as a voter, that like I'm a lot like my co-partisan in New Mexico and I'm not very similar to the guy who voted for the other presidential candidate down the street, then I think that's part of the reason we see these kind of coalitions across states to help your side and harm the other side within your state. And that's why we see fair weather friends of federalism who completely change their tune when the other guy takes power on January 20th.
Well, thanks for that, Will. I think you might be in a unique position to answer my next question, which is what do you make of the attorney generals, the 50 plus attorney generals throughout the country that have staffed up legally and either hired solicitor generals or hired lawyers to start a cottage industry of suing the federal government? In Colorado, our attorney general, Phil Weiser, a Democrat, sued the Trump administration at least 5 or 6 times over different federal regulations or statutes. And here in Texas, I think they have some experience there too. Is the attorney general litigation a good sign? Is it not as good of a sign as it may seem, or is it something else? What do you think?
Well, I suppose that I'm probably professionally obligated as an employee of the Attorney General to say it's definitely a good thing. At the very least, they pay me to do it. So, but yeah, I think there's definitely an interesting historical development here, which is, if you go back some number of decades at the Supreme Court, I think there was kind of a general view that states were not necessarily very well represented. That, early Rehnquist Court, for example, you see a lot of decisions go against states seemingly just because they didn't have the best lawyers representing them there. And one state could kind of mess it up for the other 49 by not making the right arguments in some important case. I think people have responded to that, and we now have excellent state solicitors general all across the country who represent states very well. And I think you see a lot more kind of coordination across states. You see these big multi-state efforts where either many states kind of team up to sue the federal government, or perhaps do a multi-state amicus brief that kind of tells the Supreme Court, 37 states all think this is a problem. And I think it's fair to say the Supreme Court pays attention when 37 states think something is a problem. And we see it, both on the Democratic side and the Republican side. I think a lot of people trace kind of the modern rise of state litigation against the federal government to Massachusetts versus EPA, which I think was decided in 2007. But the state of Massachusetts said that they were upset about the George W. Bush era EPA actions on greenhouse gases, that they needed to be doing more than they were doing. And the Supreme Court decided that Massachusetts was entitled to special solicitude in the Supreme Court when it came to standing. That makes a difference to whether states can even get in the door and do this litigation. So kind of increased competence at the state level, I think, combined with legal doctrine accommodating that, and then all of the same polarization stuff that you're going to wind up seeing a lot of red team and blue team multi-state coalitions, and the incentives to do that are, I think, only increasing.
Russell, go ahead.
Sure. Just to add to that, I think that for a lot of people, the reaction to the increased litigation and the staffing up of state attorneys general is kind of eye-roll inducing, and they just view it as sort of partisan gamesmanship. But I disagree with it. I think it's incredibly healthy. Whether it's a Democrat-controlled state or a Republican state suing the federal government, I think it's incredibly healthy for states to be asserting their interests in federal court, no matter what the issue is. And despite what a lot of people may think, I think that the federal judiciary is generally pretty good, and that these precedents matter, and that building on another thing that you said, that a lot of this is cultural. So it's filing these lawsuits, having it in the conversation, and a lot of the things I mentioned in my opening, that people love federalism when they're not in power. All of these things keep federalism in the conversation, and they remind people that there are mechanisms in the way that government was designed to restore the order of things. And if that is ever going to happen to the extent that we would like, all of these things need to keep happening.
Professor Griva, do you want to comment on that? And while you're doing that, I would love to hear your take on how federalism is faring in the university setting as well.
Everything's fine at Scalia Law School. Elsewhere, I'm not so sure. That's a short answer. Look, I've looked at a lot of this state AG litigation. I worked on a big project on it. It's part data work, part legal work. I am generally torn about it. I see the argument that this is sort of a pushback against sort of federal overreach, and that's probably useful. On the other hand, there are a lot of worries about it too. So for one thing, this tends to sharpen partisan bloc politics. Take the Massachusetts versus EPA case itself, okay? What that case produced was the biggest program that the EPA has ever run, completely without statutory authority. It's an amazing thing. And the standing holding there in Massachusetts EPA was part of a general phenomenon, which is there's a climate change exception to every known principle of American law. And I mean, what happened there, right? all that hullabaloo about the Clean Power Plan and all the rest of it, that might not have happened had the Supreme Court not been so eager to wade into this at the behest of 15 states. And mind you, it's not amazing that, Massachusetts can collect 15 states to sort of get into this and support it. I mean, the sign-on letters are basically cost-free. What's amazing is there were 16 states that immediately recognized what this was all about, that this would not stop with automobiles, that this is a mortal threat to the economy of the state of Texas and Oklahoma. And so we have to pay attention and litigate on the other side. What these cases are really about. I mean, we always tend to think, and the Supreme Court tends to think, of federalism cases as the states collectively, as unitary actors against the federal government. That's not what these cases are. It's blocks of states litigating against each other. One of them happens to be aligned with the federal government, and the other one is against it. And then every 4 years, is the pattern. It flips. I'll say one more thing about this, which is, these cases used to be rare, and one of the reasons why they were rare is that the conventional view of the matter was that this stuff is very, very troublesome and constitutionally troublesome, because in cases where the state government purports to represent its own citizens, the citizens are on both sides of the debate, because they're also United States citizens, right? And the United States government is at all times in full privity with each and every one of its citizens. And it's a good question whether the states can interpose themselves and for what purposes. Complicated questions. I'll skip it. I'll say one more thing about the way these cases are fought, and which gives you pause. Okay, so the way AGs do this is very well coordinated. You pick 4 district courts in the country that are in the tank for you, okay, because you know the judge. And then AGs have an advantage that ordinary citizens don't have, which is they can file in any district in their jurisdiction, right? And so, and then they go to town. And what that means is they have to win only once in 4 or 6 circuits to get a nationwide injunction, and the federal government has to run the table in the most hostile districts that it could conceivably face. And then it has to ask for an emergency stay in the Supreme Court, and that has caused an awful lot of commotion. So while I'm generally, supportive of the idea that, there has to be some pushback in preemption cases, in commandeering cases, and all the rest of it, these particular exercises of sort of saying, hold it, leave me a little uneasy. A lot of it depends on the nuances and particular circumstances, but I'm torn about it.
Derek, I have a question for you, which is, during the Trump administration and before, we've heard the term sanctuary state used a lot, commonly to refer to states that won't assist with the federal government deporting illegal immigrants or immigrants who aren't here presently for one reason or another. Do fans of federalism have to accept that sanctuary states can exist and defy the federal government? If you accept sanctuary statism for guns or other purposes, do you have to accept all the consequences that come with it?
I think that's actually it's a well-constructed and complex question, because I think there's a lot of externalities specifically on the immigration debate. When it comes to the gun debate and the sanctuary state for firearms and the legislation surrounding that, there is no, you would be hard-pressed, and as familiar as I am with the academic literature, it'd be very hard to articulate a case where there is an affirmative action that causes a harm or even something distal to that. Whereas what we see specifically out of I'd say the California sanctuary state legislation, a few years on, is something that could actually, just by not complying with already established federal guidelines and basically process and things of the ways some localities have always done it, are literally releasing violent people onto the street. Now, the issue is, and this is kind of where the constitutional order question comes into play, because here in Texas we had, I want to say, 3 or 4, I would say, serious attempts at creating similar immigration sanctuary cities before they were preempted by the state. And a lot of you hear around the on the state legislature is, well, don't you like local control? Don't you know? Again, if you're a conservative and you believe in the idea of subsidiarity, wouldn't the edifice of government closest to the people then be the most well equipped to actually solve the problem? And again, in a strict reading of Kirk, that actually would be the case. But Kirk also didn't fathom this complete capture by I would say anti-democratic minority voice forces. And when I say that, I mean people that subscribe to basically socialism and beyond, which is certainly what we have here in Austin. And so, if again, pointing to the constitutional order, whereas the federal government is basically willed into existence by the states as sovereign, so too are the political subdivisions, so too are the cities, so too are the counties. And if it is at the pleasure of the legislature and the executive that they do or do not comply with something, then they do have to listen to that. Now, that the opposite side of that coin is, yes, California then can have their dealings with ICE regulated as they see fit, because again, California is a sovereign unit there. That being said, it's obviously not a great policy to have a blanket way of treating immigration in that way. But I think that here in Texas, that only serves to reinforce the case that we can assert the sovereignty on our terms as well. The one thing I would add to that is there's a lot of, I would say, Marquis of Queensberry rules when it comes to the legal back and forth between the states and the federal government. And one thing that, one discussion I know that was hotly debated here in Austin, even though it was probably more hypothetical, was, well, we have legislators that are not within the jurisdiction that we have general law enforcement authority. What is the capacity for our law enforcement to then go and do their job in another jurisdiction? I made the point that let's go find out. But because again, it's one of these issues where, we cannot let I would say, kind of the flimsy block of jurisdiction, particularly in that case, but in many of these others that are adjacent to these issues, actually be what determines whether or not we are going to actually assert that sovereignty.
Excellent. Just a reminder to everyone, if you've got a question in your mind, remember to jot it down or make a mental note of it so that you can ask it in a few minutes when we open the floor up to questions. Will, let's talk about some of the work that you're doing at the AG's office. What fights are you involved in that implicate federalism and issues of that sort?
A lot of them. So I think I've worked on 3 cases where we got nationwide injunctions against the Biden administration regarding immigration matters. The federal government has since then sued us twice in cases called United States versus Texas. One of them was about the governor had an executive order concerning the transportation of migrants. You may have also seen recent coverage of one about the Texas Heartbeat Act, which is ongoing, obviously. And so
sorry, I don't know what you're talking about. Yeah. No, I'm just kidding.
So we have those going on. We also have cases in the Attorney General's office that hit on kind of the federalism analog involving local governments. So, of course, if the legislature passes a law meant to preempt certain decisions by local governments, like sanctuary cities or something, then we defend the legislature's choice there and sometimes have to sue the local governments to get them to stop doing whatever they're not supposed to be doing. And I guess I will say there's something a little bit unusual about this. I agree with something somebody said earlier, that the federal courts are generally pretty good, and I think they're generally underrated from people who are kind of cynical about the motivations of judges. I've never encountered a federal judge who I thought was in the tank for Texas, so it's always in some ways an uphill fight. But just fundamentally, if you're thinking of federalism as, we have 2 separate governments here, the state level and the federal level, there's something odd about saying the state of Texas has a problem with the United States, so we're going to go ask another part of the United States to help us out, right? We go to often a federal judge who's part of the federal government to say, there's a federalism problem, can you solve this federalism problem? And You might think that parts of the federal government are inclined to side with other parts of the federal government, at least sometimes. That's just kind of a feature of what happens when you're doing it in litigation rather than in kind of a cultural or political space. Hard to get around that sometimes, shall we say.
Excellent. Russell? Sorry, go ahead, Professor Grieva.
No, I mean, I was going to, maybe there's a sort of too in the weeds and too much of a tangent.
Nothing is too in the weeds for us. Yeah.
Okay, good. Let's go. I was going to mention, I mean, I completely agree with, well, there are, on sort of broad doctrinal fronts in the law, there are reasons to be moderately optimistic. I mean, they sorted that out. They tried to sort of reestablish some federalism boundaries that had long been lost until 1975 or thereabouts. That's true. There are two broad areas of the law where sort of confusion reigns or indifference reigns, and maybe since it's among and between lawyers and a legal foundation, I thought I'd point this out. One is, if you think I'm right about federalism having become increasingly executive, then the big battlefield for federalism is not so much about sort of first-order constitutional rules, right? So United States versus Morrison, Lopez, NFIB, those cases will be few and far between. In administrative law, this comes up all the time, right? And so the conflict field there is administrative law. We have we have federalism canons that are supposed to bring some order into this, right? And be federalism protective, clear statement rules and all the rest of it. And then we have administrative law canons that cut the other way. Broad deference. I mean, you have some agency rule that systematically disadvantages certain states, and you know it and you can see it, and the agency didn't say a word about it. Is that arbitrary and capricious? Beats me. But somebody ought to have an answer to this and sort of sort through the sort of intersection of administrative law on the one hand and sort of quasi-constitutional federalism canon on the other. I predict that will be a very active field in years ahead. And just to give you one example of this, I mean, the original DACA case, one of the issues there was supposing, erroneously, that that the federal government had authority to issue that program in the first place. Did they have to do it through notice and comment? Or could they just wing it and, write a memo? It's an ad law question. It also has sort of heavy federalism overtones, at least if you pitch the case right. That's just an example. And the other field that I think merits some attention is, what exactly is it that states are allowed to do to one another? And so this is sort of federalism's horizontal dimension, right? And what I'm thinking about is things like California energy portfolio standards. They're effectively so. They rate the energy and for carbon intensity, and then say, if it's too carbon intensive, we're not going to buy it, and you can't sell it here. And because they sort of calculate the transport cost and the extraction cost into the energy standards, it's a de facto regulation of energy production in Texas, Oklahoma, and for good measure, Brazil and Canada, right? It's sort of importing energy, exporting regulation. Is that permitted under the Constitution? It ought to be, if you ask me, but it isn't. The Supreme Court just sits there. Who, what? Relations among and between the states? That isn't interesting to us. They've been very, very bad about it. They've been very, very bad about products liability litigation, which has the same exploitative dynamics. If somebody could give these guys and gals a kick in the pants and say, pay attention, a lot would be gained. And I think conflicts among and between states are getting harsher and harsher and harsher. This is not just sort of accidental sort of spillovers into other states. These are deliberate attempts to harm other states and their political autonomy. To my mind, we can't have that. We used to have a doctrinal framework to combat that, and we don't anymore. And that's a front that's worth working at.
Well, I have, now that we're talking about administrative law, recently President Biden announced that there would be an OSHA mandate on employers that have 100 or more employees to either force the employees to get vaccinated or to force them to test at least once per week. And I think one of the rationales was that all of these businesses are operating in interstate commerce. So this was a valid regulation of every business in the country that has 100 employees or more. My question for the group, Will, you mentioned interstate commerce being the flip side of the coin with state power. You know, if these statutes from the last century are just lying around waiting to be picked up by an aggressive executive, what does that say about federalism when it comes to agency action and whether OSHA can regulate like this?
Yeah, I think you're right to tie together the separation of powers questions with the federalism and litigation questions. So the professor mentioned that there are a lot of administrative law questions here, and the key statute to think about most of the time when the state is suing the federal government is the Administrative Procedures Act. It basically allows, there are a bunch of jurisdictional limitations and stuff, but when there's federal agency action, then there are a lot of options for someone to bring a lawsuit. The APA creates a cause of action, it waives sovereign immunity, it provides for certain remedies. You just have all these options. The APA does not apply when Congress passes a law itself. So if Congress passes a law and says, we're going to do the exact same thing about immigration that President Biden wants to do, but we're going to do it in a statute, then states have very different and more limited options for suing about that. So the more there's kind of gridlock in Congress or partisan polarization preventing things from happening through kind of what we might think of as normal lawmaking channels, the more it gets pushed into the administrative space with agency action. And the more I think even within the administrative space, we move from notice and comment rulemaking down to something like sub-regulatory guidance, or just wrote a memo to create DACA, that kind of thing. That increases the opportunities for states and others to file lawsuits. So I think that's kind of how the relationship works there.
Russell, go ahead.
Sure. Building on your question and Will's answer, this is the biggest problem there is for federalism. So Congress can pass laws, and the Supreme Court decisions we talked about in the late 90s that kind of reined in the Commerce Clause a little bit, and the NFIB decision. So we may not be entirely happy with those, but those limitations are there as far as actions by Congress. But the problem is, Congress has already passed a law on everything. There are huge pieces of legislation that Congress has been passing for decades that authorize the alphabet soup of administrative agencies to do anything that they want. And they can reach back and find something in OSHA or Clean Air Act or anything you can think of to write a new regulation for what the president wants to do. So that's where the real battleground for federalism is. You have to be able to push back on that. But it also raises a related issue, which is another battleground, which is things where Congress has not acted and there isn't an actual regulation, but there are things that the president wants to do. So say, for example, the Attorney General of the United States issues a memo that says, hey, state and local law enforcement, we'd like you to investigate concerned parents as though they're domestic terrorists. Would you please help us? Well, right now, the states can just say, no thanks, we're not going to do that. So that's something that has to be protected, and that's probably a future battleground.
Derek?
And yes, and Russell, I think that's a very good point, especially brought up in the wake of recent events. But I think that, again, here's kind of the more pessimistic line on this is even thinking of the most conservative congressperson in existence, whomever that may be, based on your version of conservatism, has at least once voted aye on a bill that says somewhere in there the secretary shall. And so the people that are even, and it's not because it's because they're, closet monarchists or anything like that. But basically that we have built up the administrative state. We've built up agency land in D.C. to such a point where that if we don't actually, I shouldn't say if we don't, but it is seen that if we don't actually vest the power to execute laws, and when we make laws, we have an ideal execution of that if we don't give these powers on these places that already have, footprints in the area, that we're essentially hamstringing them. Is that the worst thing? Probably not. But that being said, is every single piece of legislation, no matter how innocuous, that still continues this fiction that these agencies have any sort of, legitimacy in the say over your life because they're, reading how WOTUS is to be applied to a puddle in Midland. They're reading about how the Endangered Species Act applies to, just looking at our work alone, to a spider that exists solely within McLennan County. We're talking about these issues where the Commerce Clause, and the only thing I disagree with Will on that is that I've had a very dour view of the Commerce Clause reading for quite some time, that, we're actually at a point where what Biden is proposing under the vaccine mandate, and we've obviously been very vocal on its illegality, but it's no more ridiculous than what happened in Wickard. It's no more ridiculous than what happened in Raich. I mean, this is essentially the canon that we've been operating under for such a long time, that it's the institutional inertia. This is how laws are created. This is how agencies are empowered. And I just don't know if there's anybody in D.C. who's willing to do what they can to blow up that particular element of the system.
Go ahead, Professor Grieva.
I have a sort of question, since you raised it in the first place, federalism in the academy. Derek says something about, is there anybody in Washington who's willing to stop this? I sometimes wonder, is there anybody willing in the states willing to stop this kind of stuff? And what I have in mind is this. So the Education Department's Office for Civil Rights, that's 200 people in the basement, There are not that many of...
We were on the 4th floor.
Oh, okay, good. But there weren't that many. You had a good view, too. Yeah, good. There weren't that many. I mean, there just aren't that many of them, right? And you ask yourself, where does all this tyranny on college campuses come from? And the answer is, they've managed to sort of leverage their guidance documents and this and that and the other thing into building enormous constituencies of administrators and enforcement agents on every college campus. These people are really dangerous, and they don't need any push from OCR. That's ridiculous. They would sort of go over the top with or without OCR, but they always have that, sorry, we have to do that. And then the next dean says, oh, sorry, we have to do that. And all of a sudden you're told as a faculty member, you have to do this. It's not true. You don't have to do it, but everybody tells you have to do it, right? And that has an enormous potential to, even in sort of states that want to say, no, wait a minute, we want to run responsible institutions here, to just say, whatever. And if anybody could think of sort of sensible political strategies to sort of fight back against sort of in those kinds of contexts, states actually have become subdivisions of the federal government, right? And they willingly execute much more than they are legally commanded to do. They use this as an invitation to sort of increase their own power base. There are lots and lots of contexts in which this occurs. Financial regulation and so on and so forth. I think Title IX is the most egregious example. But if anybody has any bright ideas on how to push back against that kind of stuff internally, politically, in a state that's willing to push back and say, wait, I'd be all ears.
And as a alumnus of the University of Cincinnati, we probably both being FIRE's first red light school, back when we had our little postage stamp public display area that you had to reserve 60 days in advance. But that being said, Professor, not to add to your grim assessment, but I think Mao's long march through that particular institution's about done, and I don't know how redeemable it is. Even, I know from a faith-informed perspective, if you look at Notre Dame used to be a very conservative Catholic school back in the day, and now, well, Catholic's in the title, I believe. And I mean, we still have holdouts. We still have Hillsdale. We still have Wyoming Catholic College and other good examples. People that have been able to your point, forestall the influx of federal money to build lazy rivers and climbing walls and all these other things that are important to a classical education, and a good football team. Which, of course, me being a Cincinnati fan, I can't really say anything about at the moment. But that being said, it really makes me question that. I don't know if there actually is a redemption arc for the modern academy. Now, again, you can never go home again, but can we actually think of institutions to fill that void? And I think we are seeing a lot of that with some of the virtual education offerings that are being discussed, and some of the ones that just completely wholesale replace, whether it's Peter Thiel incentivizing individuals to get trade certifications versus college degrees, or even just making or having good state policy that makes more robust options available and attractive for life after high school that does not require 2, 4, well, in my case, plus years of college. And I think that's probably more of a fruitful lane than thinking, how are we going to get Harvard just to stop being so woke?
Well, so this will be my last question before we move it over to the audience. So again, keep your question in mind. In 30 seconds or less, give me your hottest take on what you're looking at right now in terms of federalism and the fights in the next year or two. Professor Grieva, should we start with you?
Look, I'm just a boring academic, okay? I mean, the academic project is this business about state AGs and how to think about it. There's a very vibrant and active debate about universal injunction. That's one debate. About state standing, that's another debate, and I write and think about that. And the other piece I'm thinking about is sort of the intersection between administrative law on the one hand and separation of powers on the other. In particular, I mean, there's just one example. I don't know what will come of it. Delegated tax authority for federal institutions.
That's your hottest take? Delegated tax authority?
Yeah, I'm trying.
I've got a hot take. So when President Obama was in office, the Cato Institute would track the number of unanimous Supreme Court decisions that went against Obama administration actions. And it broke a modern era record. It was something like in the high 20s, far more than the decisions that had gone against Bush. And so my hot take is that the Biden administration will beat that record, although it'll be shortened for 4 years because he'll be a one-term president.
Your lips to God's ears, Russell. One thing I would say in my hot take is, I mean, there's definitely a mild take at the front end, which is keep interacting with the true locus of power when it comes to state sovereignty, and that's the state legislature. We're blessed here in Texas to have some really, really good legislators who think things through, both in what it means for putting us on the hook for future obligations to the federal government, and what it means to citizens. Thank you so much, Senator Taylor. But I would say that now the hot take, and I don't know if it's necessarily scalding, but it's definitely up there, is when it comes to asserting state sovereignty, the last question that should be asked is, can we do this? I don't want to say, so-and-so has made their decision, now let them enforce it. But there's, if we just look at, especially even in the DOJ, the IRS has more enforcement officers than the DOJ does in several of its sub-entities. There just simply isn't the federal personnel to live in this top-down monarchical system that we think we're living in.
Well, I suppose for a panel on federalism, somewhat controversial take would be that a lot of the problems people are interested in today, and maybe even a few that we've talked about, aren't really federalism problems. We're talking about some things that are just kind of partisan problems. You know, the other side's doing something that your side doesn't like, and that can manifest itself in, you know, principal agent problems. Perhaps there's a state institution of education that, you know, has been so totally captured by activists from the other partisan side that they're no longer doing what we think the state legislature might want. But that's not really a federalism thing, because as the professor pointed out, they don't need the federal government to tell them to do that. They're all on the same team. So insofar as you're a fan of federalism and a foe of some of the things that have been discussed today, I think keep your eye on what's actually happening there. Is it really something that you think you can solve by reinvigorating state power? Or is it that the state official in question is just on the other side of the issue?
All right, excellent. So let's turn it over to our crowd. Yeah, we already have a question here and a question there. Why don't we start here in the middle?
I may misspeak, but Dr. Cohen can correct me. My understanding that Texas legislature passed a law just recently that we would not allow any nuclear be done and stored in Texas. That would not happen. There's a private company that had already been asking to be able to do that. In the minute the governor signed that legislation, they got approval from the feds to go ahead and store nuclear waste in West Texas. Have I misspoken? I understand that's what happened.
So, sir, I'm actually going to have to hand this off to Russell. Did you all take a position on the debate about the nuclear waste storage? I was following it cursorily. The problem is the way we work here at TPPF is we have individuals that are definitely in the energy sector, but none actually have the specific expertise in nuclear. So unfortunately, I can't really opine on that.
So I do work for TCC, which is related to my primary employer. It's a legislative caucus, and we take a position on every bill. And our position on that bill was neutral. When we are neutral on a bill, it either means there are competing conservative principles, or there are really no conservative or opposite principles at stake. And I didn't look at that bill myself, but I believe that was a situation where there were competing conservative principles on the debate, so we didn't take a position for or against it.
You were extra neutral, you would say.
That's right.
Okay. Militantly neutral, yes. All right, we got a question over here.
Yeah, so as a libertarian, I'm contractually obligated to be sympathetic to sort of techno-futurist, make the state obsolete arguments. Do any of you see room for that kind of a technological proxy for what we used to have for federalism? Because if we can't go home again, are there other options available to us other than maybe Elon Musk's Mars colony or something?
You mean actually shrinking the government?
No, I mean just ignoring the government and doing your own thing in a parallel structure.
So, I don't want to put words in your mouth, but would like a good proxy for what you're saying would be like in the financial regulatory sector and what they're doing to Bitcoin, which is largely out of the grasp of the regulators, or at least
right. The idea is like, let's make our own currency. Let's not worry about central banking. Kind of.
Thank you, Derek, for speaking libertarian. I appreciate that.
Like I said, I taught in colleges not too long ago, so I'm still a little rusty but fluent, I would say. I think there is a massive opening for that. Bitcoin was the first one that jumped ahead, or any sort of cryptocurrency, just because that, again, takes that locus of power outside of the existing institution of government and puts it into a more popular institution, which is one that's shared across however many computers are actually plugged into that particular network. The problem is, and this is where we have my colleague Dr. Vance Ginn is definitely a classical liberal. I mean, if you want to get under his skin, you could insist he's a libertarian, but he definitely has sympathies to that too. And the problem that I point out to him, specifically on the issue of cryptocurrency, but it applies to this more generally, is that cryptocurrency is pegged to a fiat dollar. I mean, ones and zeros are great, but it's not 3 zeros and 5 ones to get a sandwich down at McDonald's. And so that's where I think it's the linkage of these, I think, technological innovations, and where does it come back into the real world, or how does it exist within the real world, where I think that's where some of that oomph is diminished. And that is where I think some exploratory policies, like I think, obviously they're talking about using the blockchain for like voter integrity and things like that. I think that those are going to be discussions that need to be had, but as of right now, I think we're not necessarily there on either the technology or the shared understanding of the technology in order to have that popular discussion.
Professor Grieva?
My answer, the question has naturally occurred to me as well, right? I'll say two things about it. And this is far from any systematic thought and of any kind. Look, when that new thing came out, the internet, right? People had, especially among my libertarian friends, people had high hopes in it. Hallelujah, here's something that is completely decentralized, right? Not under anybody's political control, has enormous liberating potential. This is also true among democracy groups around the world. The good guys, right? Who thought, finally, there is a way of sort of resisting state power and communicating outside state-controlled channels and so on and so forth. I think that optimistic sense has given way to sort of a lot more skepticism and concern about how that stuff has shaken out. If outside the United States, it's turned into an instrument of control, see China, right? And that has not been a happy experience. And so I don't know what that means in terms of the general proposition. Are there technologies out there as yet to be invented, right, that allow us to sort of step outside ordinary hierarchies? I'll say one more thing, and this is brought to mind by I fully agree with Derek. The university and college ship, that has sailed, right? That march is accomplished. We will never get these places back on track, with a handful of exceptions here or there. Really, that ship has sailed. What that means is you have to build counter institutions, right? That is to say, you cannot just say, thank you, I'm exiting, my new home is in northern Idaho. That is not an option for everyone, nothing against northern Idaho. But on a larger scale, you have to build counter institutions, right? Whether that's Christendom College or Hillsdale or whatever it is, right? Or whether it's some sort of, and this is where the technology comes in, sort of post-COVID model of education that doesn't try to sort of copy Harvard or Yale or Dickinson, right? I don't know what that looks like, but there's more involved than just a technological fix. There's a lot of organizational and infrastructure work involved in that program as well.
Question over there?
I wanted to hear a little more about something that a couple of y'all have touched on, which is the relationship between federalism and localism. Is it hypocritical for me to say President Biden shouldn't be making policy on XYZ issues, but Governor Abbott and Governor DeSantis should be making those policies? Is it arbitrary to want states to have power as opposed to the federal government or more local entities?
I would say no, it's not arbitrary at all. And Derek already made this point. The states created both the federal government and the local governments within their jurisdictions. So the states, as sovereign, can make those rules. The states did make those rules for both the federal government and the local governments. So no, it's not hypocritical at all.
I agree with Russell agreeing with me. But all joking aside is, and I see, barring constitutional guidance, I see the ambit of the legislature and that of the governor and the due execution of powers is absolute. If a representative from the Austin area had a problem with the way the police were being run in Austin, obviously we had a lot of discussion about that this session. But the solution was we want to make all Austin councilmen have to wear German-style lederhosen to the council meeting. Then they would be more than in their power to do so. Political wisdom of that I would question. But that being said, we were talking earlier about, and this point was brought up, I'd say very pointedly, is that we have this ersatz understanding of, wrongly, of the state government as an administrative subdivision of the federal government, when in fact the local governments are explicitly an administrative subdivision, whether it's through county or municipality, is an explicit subdivision of the state government, and that's why I said their control is, barring the limits put on it by the Constitution, are near absolute.
Go ahead.
Oh, I was just going to say, I won't bore the entire audience with it, but if you'd like to talk after, I would love to tell you about my intrastate commerce clause idea, which I've been pushing around the legislature for 10 years now with no takers.
Yes, try to have a growth mindset about that. Well, Will, wasn't there an issue recently involving school mask mandates and the state of Texas and localities challenging? What was the outcome of that?
There's been a lot on that. And I'll confess I was not personally involved in it, so my knowledge, perhaps one of you will correct me, but my understanding is the governor's order kind of created a right to go without a mask for students in public schools, for example. And a lot of schools seemingly thought, let's not follow that. So they just created mask mandates at their local school level anyway. And I think there was a lot of emergency litigation kind of throughout the court systems in Texas, all in the state courts, about kind of which one won. I believe the Texas Supreme Court guidance, kind of in an emergency posture that has been followed by the lower courts, was that the governor prevailed in that he does have the authority to prevent the schools from doing it. But there's also just a question on the ground of, are schools, if they weren't following the governor's order, are they following the Supreme Court's order? Which I think kind of goes to the technological question we got earlier. People say maybe the technology will give us an option for kind of evading government scrutiny. Perhaps, but it also creates an opportunity for the state to, and I mean, any government, to kind of have more knowledge about what's happening, to have better communication with its agents on the ground, that kind of thing. But even so, even as technology has developed that far, it's not as though, Governor Abbott's executive order is on the ground enforced by thousands of police officers, like out just looking for schools doing something improper on masks, right? There's always the question of, well, if they just do it, who's going to notice? Who's going to say something? How's it going to get to the ears of people who can react to it?
Well, it wasn't that that Governor Abbott was stealing power away. It was that he was imbuing power to parents who could make that decision. Okay, well, thank you for your questions. I think we'll do maybe 30-second closing remarks, and then we'll conclude. Will, do you want to start us off?
Well, thank you very much for having me. It's been a pleasure to chat. I hope that people will think more going forward about federalism. I think there are interesting things to think about, and it certainly should not be the preserve of lawyers in courtrooms. It ought to be something that citizens and voters think through, and so I'm glad you're all here to think through it with us.
And we're really, really honored to have y'all, to have our guests here in the building, and we're really thankful for both the camaraderie and the collegiality, not only on this issue, but on so many of the issues that are important to us. On the issue of federalism specifically, I would be doing my own institution a disservice if I did not remain a happy warrior on this issue. I do think that things will get better, but I think that will not be via reinvigoration of institutions are already rotted through the core. I think, much like the professor said, I think that will come almost explicitly through counter and institutions that we just haven't even dreamt up yet.
Oh, sorry, I stole your microphone. I monopolized our microphone.
Thank you all for having me. Thank you, TPPF and the Mountain States. This has been a pleasure. I've enjoyed being the Pollyanna on this panel, the optimistic sunny side. Hope to do it again sometime.
I joined the universal thanks to our moderator as well. This has been great fun. I'll end on one more note. I believe that federalism is becoming less technocratic, and that means it will become more local. There's a very high premium on centralizing stuff if you think that problems are technocratic, just a matter of getting the facts right and the science right and all the rest of it, right? Whereas when things involve not a whole lot of technological or technocratic knowledge, just sort of its values judgments, there's a very high premium on decentralization and leaving stuff with individuals and smaller communities. And you see this conflict in the COVID debate, right? Whenever the federal government wanted to centralize things, it says, the CDC, we have the knowledge. This is just a matter of the right policy, and the technocrats and the experts will tell you what it is. And it's obviously false, and nobody believed it, right? And therefore, we ended up with a rather decentralized scheme overall. And I believe there's more and more awareness of the fact that seemingly technocratic debates have a strong, at the end of the day, can't be severed from considerations of sort of values and preferences, and that maybe in those areas we're better off with a lot more tolerance for diversification and variegation.
Excellent. Well, I'm going to turn it over to my Mountain States Legal Foundation colleague, Kristen Wolgamuth, but please first join me in thanking our terrific panel today.